Hello, my magnificent young world changers. Are you ready to learn some more constitutional law and change the world? Well, this section is about the Fourth Amendment, very important amendment. It's the one that says it protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, and that right shall not be violated, and no warrants shall issue, that's search warrants or seizure warrants, no warrants shall issue except upon probable cause. And that means probable cause to believe that a criminal activity is going on or a crime has been committed. So before the police can come and make a search of your house, they have to obtain a warrant from the local court. And in order to obtain that warrant, they have to submit a sworn declaration showing the evidence that they have that some kind of crime is probably being committed on those premises, or else the warrant will not issue. If the police make a search without the warrant, and it's not some exception to that rule like an emergency situation, if the police make a search without the warrant, or if the warrant was obtained through false representations made by the police, then any evidence that is obtained in that search will be excluded from being admitted as evidence in any trial against the alleged criminal. So that is called the exclusionary rule. The evidence will be excluded, and sometimes people who are guilty of serious crimes are let off because the only evidence that we have against them was evidence that was obtained illegally through an unlawful search. And there's a lot of adverse press about that, people that are guilty of terrible crimes getting set free because of technicalities on the warrant. But personally, I would much rather have a few guilty people get off than have thousands of innocent people herded into prison because of illegal searches or falsifications made on search warrants. So some of the there is a corollary to the exclusionary rule, and the corollary is what is called the fruit of the poisonous tree. What's that about? Well, suppose that you go and you make an illegal search of Joe's house because you believe that Joe is a drug dealer. And when you get into Joe's house, sure enough, you find drugs, and you find a list of people that buy his drugs, and you even find a name and address of a guy that provides him with the drugs. But you didn't get a warrant to search Joe's house, you just made an illegal search. So all the evidence that you obtained against Joe is excluded from evidence. But you found the name and address of Joe's dealer, his supplier, and so you go and arrest that guy, who's Sam. You go and arrest Sam because you get a warrant to search his house because you have this address at Joe's house. Well, any evidence that you recover against Sam at Sam's house that you only got the warrant because of the information that you obtained illegally at Joe's house, that is what is called fruit of the poisonous tree. If you made an illegal search at Joe's house and you got illegally obtained information there, you can't use it anything that you find over at Sam's house because you only got to Sam's house through the illegally obtained information at Joe's house. The stuff you get at Sam's house against Sam is fruit of the poisonous tree. It's fruit developed by the original illegal search, and it's all got to be excluded from evidence also, and so Sam gets off the hook too. So that's the fruit of the poisonous tree. Issues that come up about whether or not a search is legal, some of them in your textbook that are really interesting are traffic stops. There's a case in your book where a guy was stopped for some routine traffic violation, and while the guy's writing up the ticket, another police car comes up, and that police car just happens to have a drug sniffing dog in the back seat, and when that car pulls up, the dog starts going nuts. And based upon the dog indicating that there were drugs in the car, they searched the car, and sure enough, they found drugs. So the drug guy in the car he went to court and said, you can't use that evidence against me because it was an illegal search. Neither one of the policemen that were there had reasonable cause to believe that a crime was being committed, so they didn't have the right to search my car. The dog sniffing was an illegal search of my car, and you can't do that. And the court said, yeah, you can, and here's the reason. Because the dog was outside your car, and he smelled the drugs outside your car, and whatever smell your car's given off outside your car, you don't have any reasonable expectation of privacy as to the smell that the car's given off. And so the dog didn't invade the privacy of your car, didn't invade your privacy. It smelled something that it could smell from outside the car. So the search of the car was legal and the evidence stays in. Don't know whether you agree with that or not. The logic of it, it makes sense. You know, the dog smells the drugs outside the car. But in discussing this over the years in class, we had one student who said he saw a video of a law enforcement officer with a drug-sniffing dog, and he had trained the dog so that the dog would go off like he smelled drugs whenever the law enforcement officer told him to do it. He'd give the dog a signal, and the dog would go nuts and start barking and carrying on, just like when he smelled actual drugs. So the validity of drug-sniffing dogs, I don't know. Another case in the book, kind of interesting, a couple was asleep in bed, naked in bed, and the police officers came believing that it was a drug house or something, and they broke open the door, forced this naked couple to get up against the wall, held them there naked against the wall for several minutes while they searched the room to see if there were any weapons concealed in the room or any drugs. And later they found out that they had knocked down the wrong door and gone in the wrong apartment and held these people naked up against the wall for several minutes while they searched the house. Well, the people sued, and they said, you know, you violated us in the worst way, forced us to stand naked against this wall, and we want money damages. And that went to court, and the court said, you know, we're really sorry about what happened to you. It's very unfortunate, but they had a legal warrant. They just happened to go to the wrong apartment number, and they did hold you there naked against the wall for a few minutes while they searched for weapons, but that's a legitimate thing for law enforcement to do when they're busting into a drug house to search for drugs. They have a right to protect themselves from weapons. You might have had guns hidden under the pillows or whatnot. And so the search that they did, everything that they did was acceptable, even though it was a mistake, and you can't sue them and get money for that. They have a certain amount of governmental immunity from that kind of conduct. So that's the naked couple test. Another issue that comes up has come up in the past is school systems or sports parts of school systems have required students who participate in after-school athletics to go through drug testing from time to time. And the issue is whether or not it's okay for schools to require students who participate in athletics to go through drug testing. And the courts have said, yes, it's okay because those students are volunteering to be in those after-school sports programs, and they have to understand that there's a legitimate government interest in keeping drugs out of competitive sports and out of students in schools, and the random drug testing of the student athletes is one of the prices we have to pay for protecting the students and the athletics. Another case that may surprise you, there was a man who was arrested in the state of Washington as a voyeur, and he was taking a camera, and he was standing under an open staircase in a shopping mall, and he was shooting photographs. This is in your textbook. He was shooting photographs of women as they went up the stairs. He was taking pictures up their skirts. And so they arrested him and said, this is an illegal activity. You're invading the privacy of these women. It's lewd. It's indecent. And the state of Washington court let him off. And they said the reason why we're letting him off is it's a public place. He's standing under the stairway there at the mall, and women who wear skirts and choose to walk up that open staircase do not have a reasonable expectation of privacy. Therefore, their privacy is not being invaded, and so we have to let this pervert go. How do you feel about that one, ladies, especially feminist ladies? How do you feel about that one? Wish we had could converse in person. We could have an interesting discussion. So that's the stairway case in the state of Washington. Now, the only other case regarding the Fourth Amendment that's in your textbook is Galrysiak, or Galrysiak. I'm probably not saying it right. Gawrysiak, the Galrysiak case. And this is where law enforcement officers went into a place of business to search for evidence of some criminal activity. And some criminal evidence was found, and then when the thing went to court, or was getting ready to go to court to prosecute the criminals, the defense lawyer said the warrant that was issued by the judge was too broad and all-encompassing, and so it was an invalid warrant, and so all the evidence obtained by that warrant should be thrown out. So the court looked at the warrant. They said, you basically gave them the right to come in here and search everything in this place of business, and that's just too broad. And the court looked at the warrant, and they said, no, you know, this warrant was limited in 3 different ways. First of all, it was limited to a search for certain types of crimes like wire fraud. There was only like 2 or 3 specific types of crimes that they were allowed to search for evidence of, those crimes only. Secondly, it was only limited to evidence of the commission of crimes by 2 or 3 certain people, named individuals who worked at that company. So not everybody at the company. Only evidence against 2 or 3 guys. And finally, it was only a warrant for obtaining evidence for possible criminal action taking place during a certain limited time period, that is, from 1992 through 1995. And so it was not too broad and all-encompassing, and so the evidence that was obtained in that search will be admitted as evidence. So these are some of the issues that come up around the Fourth Amendment. But remember, if the search is not legal, then all of the evidence that is obtained through the illegal search will be excluded. And if there is fruit of the poisonous tree, if there's evidence that's discovered in that illegal search that involves somebody else, that'll be fruit of the poisonous tree, and that will be excluded also. That's their Fourth Amendment, protecting you against unlawful searches and seizures.